Hearing in the appeal, Wells against Devani.
Mr. Warnock,
May it please my lords.
we were discussing things and thinking that the written cases had been very well presented, the issues clarified, and we wondered whether leading counsel would necessarily need the 2 hours which has been granted to
Well,
them.
I'll do my best.
If you don't need 2 hours, don't feel that you need to spin things out, Mr. Warnock.
If I can sit down early.
Same goes for Mr. Butler. We also felt, I don't know what you think, that 3 hours, 10 to 1 is quite a long stretch. We wondered whether we'd take the luncheon adjournment at 1:45, start again at 1:45. Do you think that would be reasonable?
Well, that sounds a very sensible.
Good. Mr. Warnock.
My lords, may it please you, I appear on behalf of the appellant, Mr. Devani, along with my learned friends, Mr. David Giles and Miss Laura Giacardi. For the respondent, Mr. Wells, my learned friend, Andrew Butler, one of Her Majesty's counsel, appears along with Mr. Edward Blakeney. As my lords will have seen from the statement of facts and issues, this is the appellant's appeal against the decision of the Court of Appeal, which by a majority in turn had allowed the respondent's appeal against the decision of His Honour Judge Maloney. It's a case concerning an estate agency fee. My lords, I propose to go very briefly to the statements of facts and issues.
Well, we've read the statement at least once.
Yes.
Probably twice or 3 times.
Then
Anyway, it's all recited in the Court of Appeal.
it is.
You want to flag anything in particular up?
Well, my lord, can I just flag this, that the heart of the case, at paragraph 9, the judge set out what the central factual debate was. And that's on MS 30.
Yes.
And at paragraph 10, he made findings of fact in relation to that, of which I suppose the most important are C and D. In relation to C, where he found that the findings he made in relation to the discussion about commission, it's also worth just picking up that at MS 34, paragraph 26, it's clear, contrary to what the majority in the Court of Appeal said, that the judge also accepted or found that Mr. Wells had accepted the 2% fee, and that's the last paragraph of 26.
Yes.
The parties thereafter, after the crucial conversation in relation to which the judge made those findings, then conduct themselves very much as one would expect. Following the appointment of an estate agent, Mr. Devani found a purchaser. He contacted Mr. Wells, arranged an appointment for a viewing, and it followed through into an offer, which Mr. Wells then notified Mr. Devani of, and also gave Mr. Devani his solicitor's details in the usual way. And the issue which arises, we say first, and I propose to address the issues in this way, is what did the parties agree? Secondly, was what agreed sufficiently certain? And that involves looking at interpretation and implication. Thirdly, I propose to deal with the Scan Carriers case. And fourthly, the point raised under the Estate Agents Act. And
Yes.
Respondents'
The latter
objection.
should be left to reply, can't it? Because it's essentially a cross appeal.
Yes. Lord Sumption was suggesting, actually, why don't you park your submissions on the Act and make those in reply?
Yes. In relation to what did the parties agree, the question, of course, my lords, is what they objectively have agreed, not the narrower question of what did they say. And we have set out in our case, I don't propose to go to this particular authority, but at MS 47, in our case, at paragraph 10, we've set out the rather uncontroversial dictum of Lord Clark.
Yes.
In the RTS Flexible Systems and Mulcahy Muller case. And I don't think there's any dispute about these general principles. One's looking for what they agreed, which can be determined by what's communicated by words or conduct, and looking to see if they intended to create legal relations and agreed upon all the terms which the law considers essential. And we say the judge here was satisfied that Mr. Devani and Mr. Wells had agreed that Mr. Devani would seek to find a purchaser for Mr. Wells' flat in exchange for a commission if he did so. And we see that at MS 126.
Sorry, MS?
126, page 126. At paragraph 2.19, the judge said, "It follows I conclude there was at all material times an oral contract between C and D entitling C to payment of a commission of 2% plus VAT if C effected an introduction between D of a prospective purchaser of the flats, as a result of which that purchaser bought those flats."
So your case is there's a finding that the agreement was that if he effected an introduction, quote unquote, and the task is to interpret what affecting an introduction means.
Yes.
Is that the point you're making?
That's the point. And indeed, that was the way my Lady Justice Arden approached it in the Court of Appeal. And in fact, we say there doesn't seem to really have been much distinction between what Lord Justice McComb thought either, because if we see it, MS page 107, MS 107.
Yes.
At paragraph 80, Lord Justice McComb said, "The judge found that these parties intended to reach and did reach a legally binding agreement. I would not and do not disagree with the judge's finding of fact that they intended to make an agreement then and there for Mr. Devani to act as Mr. Wells' agent on the sale of the residual flats in the block. However, for me, the question is whether what they are found to have agreed upon amounted to a completed agreement capable of constituting a binding contract, and I answer that in the negative." Then he says, "The intention was that Mr. Devani would be Mr. Wells' agent in seeking out a purchaser of the flats in question. He was..."
The finding that the judge made at paragraph 219
Yes.
effectively means that to earn the 2%, Mr. Devani had to introduce somebody who turned out to be a purchaser,
Yes.
i.e., not just to introduce them, but to introduce somebody who would end up by completing the contract.
Yes.
Now, one view of that is that you don't need to bother with implication. That is effectively a contract which identifies what you have to do to earn the 2%, so that there is an express agreement, when you
Yes.
properly analyse it, that once it's done, the 2% is payable. Implication just doesn't come into it.
And indeed, that's the view Lady Justice Arden took.
Yes.
Because where the Court of Appeal we submit seemed to, the majority in the Court of Appeal fell into error, was Lord Justice Lewison and Lord Justice McComb were looking for express words. Because the judge didn't make a finding that the express words, "find a purchaser," were used in the conversation, the Court of Appeal seemed to have thought, well, that was the end of it. But what we say, of course, is that contracts arise not just by reason of what the parties said, but what they intended to agree, which involves looking at the conduct of the parties judged against the context of the whole.
Well, it's a question of what their express agreement meant.
Quite. And here, if you appoint an estate agent, if you're a vendor seeking to sell flats, and you approach an estate agent and agree a fee with them, the only sensible or realistic interpretation of that is that you're asking the estate agent to find a purchaser. And then, as my Lord says, the issue becomes, what does find a purchaser mean? And as
it could mean somebody who makes an offer. It could mean somebody who exchanges a contract. It could mean somebody who completes a purchase.
It could.
But as I understand it, you're saying it doesn't matter. Is that right, Mr.
Yes,
Moore?
and in fact, what we're saying is there is, in fact, a default position on the authorities in that the absent words to the contrary, the default position is it's upon completion.
Well, that's
Lord
what.
Denning's analysis.
Yes.
In the cases.
That's Lord Justice Denning.
Yes.
And is it Lord Justice Jenkins too?
It is in the
Yes, very well.
case.
But it's what the judge seems to have found, because as a result of which that purchaser bought those flats. You don't buy the flats. You aren't a purchaser in the fullest sense of the word
Yes.
Until the purchase is completed.
Yes, and the commission, of course, is payable on the sale price.
You are going to deal at some point with paragraph 34 of Justice Lewison's judgment, which is really where he sets out what he regards as the sort of factual difficulties about your position
Yes.
in some detail.
Yes, the fact...
That would be helpful, Mr. Warnock, please.
The factual difficulties, as I understand it, that he identified were that, this comes back to the point I was making a moment ago, that the words find a purchaser weren't spoken, because if one looks at paragraph 28, where he cites from the cross-examination of Mr. Devani, he said, yes, sir, you're absolutely right. What was discussed here is the 2%. If I find in my head, I find a purchaser to buy the property. And so later on, just the fee, just the rate was discussed. So the issue which seems to have troubled Lord Justice Lewison is that those words to find a purchaser weren't spoken. In fact, I've already mentioned in a summary of the facts, Lord Justice Lewison seems to mistakenly have thought the judge hadn't made a finding that the commission rate was agreed.
Where does he say that?
Back at the beginning of the paragraph 6, the bottom of paragraphs, MS 90.
Failure to identify the sum to which the percentage will be applied.
Yes. Nor the circumstances in which it would be payable, nor even that he'd agreed to it.
Well, yes, that's the trigger point, isn't it?
Yes.
Yes?
But was there any doubt about the sum to which it was?
No, there was never any
It's
suggestion.
really, although he mentions that there, it's really the trigger point.
Yes,
You know.
that was always the respondent's objection, which was that the specified trigger point hadn't been identified.
Yes?
And what Lord Justice Lewison seems to have approached the facts on the basis of, if one turns over, in fact, from paragraph 34 to paragraph 38, in explaining why he disagreed with Lady Justice Arden, he said, if one is to interpret a contract, the first question where the contract is oral must be what words were spoken. And the judge made a clear finding of fact that nothing was said about the trigger event. And this is where he refers to the facts, as my Lord Carnworth was referring to, about, he said, it was in his head, nor did the phrase appear in his statement. So there was no evidence that the phrase was uttered. And although Lady Justice Arden treats the judge as having found that he agreed to find a purchaser, those were words that neither party used.
There are some things that don't have to be spelt out because they are obvious given the nature of the transaction that is being considered.
Yes, and we say that's this case. It's obvious if one's going to an estate agent to sell flats that one wants the service one's expecting is that the estate agent will find a purchaser. As to the meaning of find a purchaser, if I can go quickly through some of the...
He was also concerned, wasn't he, that the actual words, the contract which was eventually found was different to the one which actually was in the terms which were supplied.
Yes, of course that's not, we would submit, relevant in the sense that the contract was made on the judge's findings during the crucial conversation.
Yes, but it's slightly odd to think of the agent in his mind entering a contract which is different from his standard terms which he then supplied.
Yes, although of course when one's judging contract formation, one doesn't go into the minds of the actual parties, but the minds of the hypothetical reasonable parties who were making the agreement. One's looking at it objectively. So the fact that Mr. Devani may have hoped for an even stricter condition isn't really here nor there if objectively judged what the parties agreed at the time was commission payable on the time of completion. By the time Mr. Devani produces his conditions, it's too late. Yeah. The contract has been made. The contract is a contract for a service. Payment doesn't become due for that service until completion, but by the time Mr. Devani provides his conditions, the service which he has offered to undertake has been performed.
So you want us to look at one or two of the authorities?
Yes. Can I start with
I was rather surprised by how many authorities, not surprised, but there seem to be an awful lot of them saying more or less the same thing.
Yes.
Is there not a simple sort of textbook summary of what it all says?
It's uncontroversial.
My
isn't
Lord
it?
Justice Lewison.
Well, of course, that's true. But if one's allowed to take some,
I'm not planning to
I mean,
trouble
it's
my
all
lords.
basic Cheshire and Fife and stuff.
No, I'm not planning to trouble my lords with all the authorities. But I thought it might be worth just looking at a couple.
Yes, let's look at a couple.
James and Smith is
Thank
at
you.
tab 11, MS 450.
Did you say 460?
450, 450.
450. Thank you.
This case was actually decided in 1921, although it made it into the law reports in 1931 as a note to another case called Martin and Perry and Daw. But the essential facts are shortly stated in the head note. The agreement was to sell a freehold of the Central Hotel for a certain price and to pay a commission if that price was achieved. The plaintiff introduced a purchaser who signed a contract, but he was unable to complete the purchase. The plaintiff claimed commission. He lost because the court held it had to be a purchaser he was able to complete. But along the way, the court had to construe what this agreement meant, and Lord Justice Banks at MS 451, page 318 of the report, said just below the second paragraph, about 7 or 8 lines up, it is necessary, as I have said, to imply consideration moving from the plaintiff into the agreement to make it a complete contract. And if that consideration were written out and added to the document, it would be in consideration of your finding for me a purchaser. What is the meaning to be attached to these words? They mean and must mean a purchaser ready and willing and able to purchase in the sense of a purchaser able to purchase and able to complete as well. They do not mean and cannot mean a purchaser in the sense either of a man of straw or a man without means. So in fact, his lordship had no trouble resorting to the implication process in order to make sense of what the parties had agreed.
That's implication rather than interpretation.
It is. I would submit it is.
I wonder. Anyway, perhaps
Yes.
it doesn't matter.
Well, it was so described, but whether it actually is.
Yes. I mean, inevitably.
The point, I suppose the point you're making is the agreement was commission if the business is sold.
Yes.
And the Court of Appeal seems to have little difficulty in saying, well, we must work out what this means.
Exactly.
They didn't throw their hands up and say
No.
an incomplete contract. Is that the point you're making?
That is the point. And,
Very well.
And essentially, the other judges take the same approach.
Yes.
Lord Justice Atkin, page 454, thinking he's implying a term, says there has to be an implication made.
Yes?
The other case I was going to touch on, because the Court of Appeal referred to it, is the Luxor case.
That's a very well-known case.
That's what, sorry?
That is a very well-known case.
Yes. I'll take it shortly. It's at tab 15, page 504. Luxor and Cooper. The issue here was whether the vendor essentially was allowed to change their mind and pull out of the sale at any point. The House of Lords held the vendor was absent any specific provision preventing him.
Allowed in the sense that if they did that, they wouldn't have to pay the commission.
Right. People can change their minds
Yes.
if they put properties on the market. The particular passages I wanted to go to are, first of all, a passage which was partially cited by the Court of Appeal at 515. the bottom of MS 515, the Lord Chancellor Viscount Simon said, there is, I think, considerable difficulty and no little danger in trying to formulate general propositions on such a subject, for contracts with commission agents do not follow a single pattern, and the primary necessity in each instance is to ascertain with precision what are the express terms of the particular contract under discussion, and then to consider whether these express terms necessitate the addition by implication of other terms. And then a passage not in fact cited by the Court of Appeal: there are some classes of contract in which an implied term is introduced by the requirements of a statute, for example, under the Sale of Goods Act or the Marine Insurance Act. There are other contracts where an implied term is introduced by the force of established custom, for example, the necessity of a month's notice in the case of hiring a domestic servant. But in contracts made with the commission agents, there is no justification for introducing an implied term unless it is necessary to do so for the purpose of giving to the contract the business effect with which both parties to it intended it should have. And we submit that is, in fact, an important part of the judgment not cited in the Court of Appeal. And then the Court of Appeal went on to set out, if I can invite your lordships to read it, the different types of estate agency contract or commission contract identified in that case, and the rest of MS 516. So what we say is there's nothing in any of that which precludes a court from interpreting or seeking to get to the bottom of what it is the parties must be taken to have agreed, whether that's a process of interpretation or indeed, as expressly recognised here, a process of implication.
And the trouble about thinking in terms of implied terms is that you sort of feel you've got to work out precisely what the term was.
Yes.
Whereas, I mean, your main point is here, it doesn't really matter because although they may have wanted to deal with a sort of term which was related to the exchange of contracts, in practice they went further than that, and so it really doesn't matter.
Yes, I'm hesitant to sort of come into the debate which arose in the Marks and Spencers and
yes,
Arabis
I thought you
cases,
might be.
particularly given the constitution of the court I have with.
Yes, well, I don't think we're going to reopen that, unfortunately.
But I'm not sure there was much difference ultimately. In one point, my Lord Carnwath said in that case that ultimately, whether the object is to get to understand what the parties intended, to get to what the parties meant. And processes of interpretation and implication are both ultimately ways of getting to that position. If it helps, it was my Lord said it it's at tab 16, MS 553 is the case.
Your primary case is that this is a case where we can interpret
It is, yes.
the words used,
Yes.
and the conduct of the parties together.
Yes.
But do remind me of what I said.
You said that
We get
MS,
distracted.
at paragraph 68 and 69 of your judgment on MS 579, it's really paragraph 69. You said you saw no reason to depart from what was said in the Belize case. While I accept that the more stringent rules apply to the process of implication, it can be a useful discipline to remind oneself that the object remains to discover what the parties have agreed or must have intended.
No, quite. Thank you. Yes? Where do we go now?
The next case I was going to go to just very briefly, but it sounds like my lords have read it, is the dictum of Lord Denning in the Dennis and Goody case, which is at MS 363.
Sam? 5. Very well.
And the actual dictum appears at MS 370. And if I can invite my lords to read MS 370 from the word so many cases across to 371 to McCallum and Hicks.
Across to where?
To McCallum and Hicks at the top of page 285 or 371, MS 371.
Very well, we'll read that to ourselves now.
And
I think we've done that.
then, as my lord...
Was that cited before the judge? I mean, the words, if he succeeds in effecting the sale, we see echoed in the
I didn't appear below, so I don't
judgment
know.
here. I mean, it's the same words. And
yes.
It's quite helpful.
And then, finally, in relation to this line of authorities, as my Lord Wilson, mentioned, there is the judgment of Jenkins in the Midgley Estate and Hands case, which was certainly referred to by Lady Justice Arden, and that's at tab 17, MS 582. And at 585, Lord Justice Jenkins, with whom Lords Justices Somerville and Morris agreed, MS 585, said, so far as any general principle is deducible from the authorities, it's halfway down the page, their effect may, I think, be thus summarised. The question depends on the construction of each particular contract, but prima facie, the intention of the parties to a transaction of this type is likely to be that the commission stipulated for should only be payable in the event of an actual sale resulting. The vendor puts his property into the hands of an agent for sale and, generally speaking, contemplates that if a completed sale results and not otherwise, he will be liable for the commission, which he will then pay out of the purchase price. That is, broadly speaking, the intention which, as a matter of probability, the court should be disposed to impute to the parties. It follows that general or ambiguous expressions purporting, for instance, to make the commission payable in the event of an agent finding a purchaser or in the event of an agent selling the property have been construed as meaning that the commission is only to be payable in the event of an actual and completed sale resulting, or at the least in the event of the agent succeeding in introducing a purchaser who is able and willing to purchase the property. That is the broad general principle in the light of which the question of construction should be approached. But this does not mean that the contract, if its terms are clear, should not have the effect in accordance with those terms.
Yes, thank you.
Before I leave this point, I'm not going to take my Lord's to them because I think the principles are uncontroversial. But of course, the court, as a matter of general approach, we've set it all out in our case. It's the Scammell case, firstly, does its best to give effect to the intentions of the parties. Secondly, where the parties have actually not just made an agreement, but acted on it and executed it, the likelihood of a contract being found becomes much greater, and it becomes much more unrealistic to submit that there wasn't an intention to create legal relations or that there wasn't a sufficiently certain contract. But I've set all that out in our case. Can I just deal briefly with the Scancarriers?
Yes, please.
Case, because
Definitely.
that seems to have been the point that the Court of Appeal got interested in. And it's at tab 22, which is MS 708. The facts of the case, as my lords will know...
Sorry, which page again?
708, 708.
Tab 22.
Okay.
The appellants operated ships. The respondents were exporters of waste paper. The appellants issued a quotation of a freight weight to the respondents for carrying their waste paper over a certain period. The respondents delivered some waste paper for shipping. The appellants short-shipped it, but scheduled the delivery of the rest for later. The respondents refused to pay and claim damages. And what the respondents sought to do was they sought to construct out of the quote a rather elaborate contractual relationship which entitled them to have their materials, their paper shipped on turning up without it being put forward for another date. The telex upon which the respondents relied is set out at page 709, the bottom of the right-hand column in Lord Roskell's speech. And its last two paragraphs, it's following our discussion on Friday the 29th of January. We agreed to a promotional rate of US $120, and this rate will be held until the 29th of July 82. This rate is to cover your paper waste, which is to be shipped on your pallets or skids and will be loaded onto our vessels as utilised cargo. Overall pallet height from ground to top of cargo not to exceed 8.5 feet. And then at the bottom of 710 on the right-hand column, his lordship says that the view which appealed to the Court of Appeal was that the contractual relationship seemingly had not been included, it was based on implying into the telex terms which were certainly not expressed in that document. The only expressed terms in the telex related to period, freight rate, and manner of stowage. Telex contains no references to the quantity of cargo. It contains no references to any number of shipments, nor to dates of any suggested shipments, nor does it refer to intervals between any such shipments. Following this approach, the Court of Appeal felt able, by adding implied terms to the few expressed terms already mentioned, to create a contractual relationship which certainly the parties had not expressed for themselves. The Lordship sympathised with a wish not to allow parties to have made a firm but uneconomic bargain too readily to escape from its bonds when it subsequently proves financially disadvantageous. But the first question must always be whether any legally binding contract has been made, and this is the dictum the Court of Appeal referred to. Until that issue is decided, the court cannot properly decide what extra terms, if any, must be implied into what is ex hypothesi a legally binding bargain, as being both necessary and reasonable to make that legally binding bargain work. It is not correct in principle, in order to determine whether there is a legally binding bargain, to add to those terms which alone the parties have expressed further implied terms which they have not expressly agreed, and then by adding the expressed terms and the implied terms together, thereby create what would not otherwise be a legally binding bargain. And what we say in relation to that, it's a very elegant statement, and very appropriate to the facts of the scan carrier's case. But it plainly cannot provide a universal answer to what is enough to amount to a legally binding agreement. It begs the question of whether there is an agreement in the first place. And indeed, if one looks down, one sees that the real reason this case failed, at the bottom of the paragraph, on the column on the left on page 422, the court held to suggest, and it's where the law reporter's lines are, to suggest that following the receipt of the telex, the respondents came under any contractual obligations to the appellants is to read into the telex provisions which are not found in its language. Indeed, the very difficulty which the respondents found in formulating an analysis of the telex, which gave contractual efficacy to it, including that it be added any consideration moving from the respondents to support any promise by the appellants, suggests to their lordships that no contractual relationship was in truth ever intended to be created when the telex was transmitted to the respondents. In their lordships' view, and in the most respectful disagreement with the Court of Appeal, but in agreement with Mr. Justice Wallace, this telex was no more than a quotation of a freight weight, which was to prevail down to the 29th of July 1982 as the rate which the appellants would charge for any cargo of waste paper which might subsequently be sold by the respondents and accepted by the appellants for shipment from New Zealand to India. Put colloquially, the telex was a quote and no more. So one can easily see on the facts of scan carriers where there's a simple quote as to the rate that will be charged if you produce stuff for shipment and you accept it, that doesn't give rise to a contract the parties had clearly not intended, but it's far removed from the facts of the present case.
So you say about this that if there's no intention to create legal relations, you can't start shoving terms in.
Yes.
in an attempt to convert it into a legal relationship. Is that right?
That's what we say, and we say it's plain here, and indeed the judge found, and indeed the Court of Appeal and the majority seem to have accepted that there was an intention to create legal relations.
Well, Lord Justice Millett had something to say about this, didn't he? Had we better not look at that, Mr. Warnock?
Yes. Yes, in the Little Encourage case, which is at tab 13, MS 462. My Lords will recall that the issue in this case was that there was an option in a lease which could only be exercised if the one of the conditions for its exercise was that the tenants had to have agreed with the respondents a further business plan and a further business agreement. It was a public house case, a franchise case. And the tenants wanted to exercise the option, but the landlord simply refused to enter into any negotiations for a further business plan or business agreement. And the issue therefore arose as to whether or not the option could be exercised. And what the Court of Appeal held was that the relevant term which is set out in the head notes, condition 1C, the requirement that the appellant should agree a further business agreement, but what that should have the words "if so required" read into it, so as to give it efficacy. So in fact, as a matter of interpretation, the Court of Appeal didn't have any difficulty in making sense of the option agreement or the lease with the option in it by reading in words. So comes back to a point touched on earlier in relation to is one implying or is one interpreting. Sometimes it's not easy to see the difference. But Lord Justice Millett, along the way, said paragraph, page 467, 466, paragraph 4, he said an option to a lease, like any other option, is a unilateral contract under which the grantor undertakes to do something if, but only if, certain conditions are satisfied. And then jumping over to page 467 at paragraph 5, he said it's in general impossible to imply terms, that is to say, terms which impose legal obligations into a unilateral contract. This would be to imply a contractual obligation on a person who, ex hypothesi, is not yet a party to any contract and therefore not subject to any contractual obligations on the ground that it's necessary to bring a contract into existence. This is wrong in principle. See the Scan Carriers case. So he cited the case for that proposition, which...
Well, in Scan Carriers, if there'd been a contract, if it had developed into a contract, would it have been unilateral?
Well, no, because, and this is what we submit, if the contract becomes performed, then it ceases to be unilateral. And indeed, the courts have had no problem in unilateral contracts in implying terms where there has been performance. And one example we give is the Forex case, which...
This statement by Mr. Justice Millett, as he then was, assumes that you can only imply terms into something that has already been shown to be a contract.
Yes.
But I don't see why that should be true. If I make an offer which as yet is unaccepted, and the counterparty eventually says, done, the contract comes into being at that point. But before he says done, it's still legitimate to construe the offer and possibly to imply things into the offer which go without saying. Then you know what it is that the counterparty is saying done to when he does say it. The idea that you can only construe or imply terms into something which is already a contract seems a slightly odd concept.
Well, I would agree with that. It seems somewhat artificial, actually. And in fact, we would submit somewhat inconsistent with what in reality the Court of Appeal did in this case, because the Court of Appeal did read words in to the option. So whether one is, it seems a rather fine distinction to say that one can interpret it by reading those words in, but not, in fact, go on to, if the stricter conditions for implying a term are met, not imply a term.
Well, Mr. Warnock, all one can say is that Lord Justice Millett does not agree with your submissions just made to us about what scan carriers was all about.
No. But on the other hand, he doesn't give any detailed explanation of how he's reached the view that scan carrier says this. And in fact, one doesn't find any analysis of unilateral contracts in scan carriers at all if one reads the judgment.
Well, what he's basically done is to take Lord Justice Roskill's formulation out of a particular legal and factual context in which he uttered it and given it an altogether general meaning as a proposition of law, whereas I think your submission is really only understandable in the context of the issue that was before the court in Scancar.
Yes. Yes, he doesn't cite any other authority for that proposition. And indeed, nor did Lord Roskill in Scan Carriers cite any other authority for the proposition that's become known as the Scan Carriers principle in the Court of Appeal.
And it comes back to this problem of treating implication as distinct from interpretation. I mean, if all you're trying to do is to find out what the offer or the unilateral contract or whatever it is means, then obviously you can see whatever's implied in the necessarily implied or goes without saying in what's been said.
Yes. And as I say, the decision that you we do go so far as to say that there is no reason, and we've set it out in our case, and we've also cited some of the academic writing on that, why one cannot imply a term in a contract which remains unilateral, but clearly where a contract has been performed, the courts have had no problem in implying terms or interpreting them. And the example we have given of that is the Forex case, which is at tab British Bank of Foreign Trade and Novinex, which is at tab 3, MS 324. And that was a case where the defendants were bulk buyers of oilskin suits, and they agreed to pay a commission to the claimants for any purchases that they were able to make from businesses introduced by the claimants. I think there's an error in our case in that we said any sales, but it should be any purchasers, paragraph 53. Nothing was actually said about what rate of commission would apply to those introductions. Introductions were nonetheless effected and purchases resulted. And the Court of Appeal in that case rejected an argument that the commission agreement failed for uncertainty. And if one looks at the headnote at MS 325 at the holding, the first holding about the middle of the page, since the contract was executed on one side by the plaintiffs having put the defendants in direct touch with P&G Trading Co. Limited, there was necessarily implied from the conduct of the parties a contract that in default of agreement a reasonable sum was to be paid for the commission. And at page 330, MS 330, Lord Justice Cohen, at the bottom of the page, last paragraph on the page, said, I turn next to the main question, is this an enforceable agreement? A number of authorities have been cited to us that I do not propose to refer to in detail, because in my view the effect of the authorities is stated correctly in the learned judges. That was Denning, where he said, the principle to be deduced from the cases is that if there is an essential term which is yet to be agreed and there is no express or implied provision for its solution, the result in point of law is that there is no binding contract. In seeing whether there is an implied provision for its solution, however, there is a difference between an arrangement which is wholly executory on both sides and one which has been executed on one side or the other. In the ordinary way, if there is an arrangement to supply goods at a price to be agreed or perform services on terms to be agreed, then although while the matter is still executory, there may be no binding contract, nevertheless, if it is executed on one side, that is, if one does his part without having come to an agreement on the price or the terms, then the law will say that there is necessarily implied from the conduct of the parties a contract. that in default of agreement, a reasonable sum is to be paid. So certainly, quite apart from the issue as to whether what Lord Justice Millett said about the scan carriers is right in relation to a contract which remains unilateral, there's certainly, we submit, it cannot be right in relation to a contract which becomes bilateral because it's been performed.
But isn't that, I mean, the idea of a reasonable sum being fixed by the court is quite a familiar one, whether has that been applied to other sorts of terms besides the price?
Well, in a sense, we submit all those cases about the courts interpreting what does find a purchaser mean or find a sale is another example of the courts doing that in a different sense.
Yeah, I mean, this doesn't really add anything to the...
No.
I mean, although one finds Lord, Mr. Justice Denning saying the same sort of thing as you said later in Court of Appeal.
Well, where are we going next, Mr. Warnock?
Well,
looking at your headings,
yes.
We've done 1, we've done 2, we've done 3. We respectfully suggested you might park 4.
Yes. I think
what else is there to say?
I think that may be it. We've referred in our case to the academic criticisms. Like I say academic, one of them is by Nicholas Strauss, QC. But the commentators' criticisms of this case and of
The case
this...
has not been received with universal plaudits.
It has not. Neither this nor the so-called scan carriers principle. But, my lords, unless I can insist you further, those are the appellants.
Thank you very much, Mr. Warnock. Mr. Giles, are you going to follow?
My lord.
Thank you. Yes, Mr. Butler.
My lords, in my submission, this case becomes much simpler if it's taken in distinct stages. The first question must always be, as Lord Roskill recognised in the scan carriers case, whether or not there is a binding contract. The misunderstanding which in my submission scan carriers has sometimes given rise to is that it's interpreted as meaning that the question of whether there's a contract can only depend on the express communications of the parties. In my submission, that is not so. And that is not so for the reasons given in the RTS Molkerai case, where the general principles as to whether or not a contract has been reached are set out. And it is worth having those words in mind. They can be found at page 694 of the authorities bundle.
That's tab 21, is it?
Tab 21, my lords,
Thank
yes.
you. Yes.
And what is said there is that...
Whose judgment are we reading?
We are reading, my lords, from Lord Clark's judgment.
Very well, yes.
Whether there is a binding contract between the parties, and if so, what terms, depends upon what they have agreed. It depends not upon their subjective state of mind, but upon a consideration of what was communicated between them by words or conduct, and I emphasise those words, and whether that leads objectively to a conclusion that they intended to create legal relations and had agreed upon all the terms which they regarded, or the law requires, as essential for the formation of legally binding relations. Now, I submit that that's an accurate statement of the law. And scan carriers must be understood to be saying nothing more than that if you have no binding contract, then clearly it is nonsensical to start talking about the process of implication of terms into a contract or interpretation of a contract. And as a matter of logic and common sense, that is surely incontrovertible.
It doesn't follow that there's nothing else that you can interpret or imply terms into. You can imply terms into an offer.
Well,
you can interpret an offer.
Well,
and when that offer is accepted, you then know what's been accepted.
Well, my lord, in my submission, what one is in reality doing in such a circumstance is interpreting the offer against the background in which it is made. If one treats the process of implication of terms into a contract as a discrete part of the process of contractual interpretation, plainly, as a matter of logic, one can't start to undertake that exercise until one is satisfied that there is a contract.
But why is that so? let's take a simple sale of goods case, for example. There's an implied term that the goods will be of merchantable quality. Now, I say, I offer to sell you a ton of beans at such and such a price. Now, why can you not say the implication of that is that I'm offering to sell you a ton of merchantable beans and not any old beans? So that if somebody simply says done, that's the deal. I mean, what the word done doesn't tell you any more about what's been done. You have to look at the offer.
Well, my lord, I entirely accept that as a matter of colloquial usage, one could be said to be implying that into the offer.
It's not just colloquial usage. You're simply saying, if I'm offering that, what is implicit in that? Not just what does it mean, but what does it imply?
But, my lord, the process of implication, and this I respectfully submit is trite law, must depend on what is held objectively to be in the mind of both parties at the time the contract is made.
That's the process of implication into a contract. I'm suggesting to you that you can imply something into a unilateral statement, such as an offer.
Well, my lord...
It's certainly not a process of contractual construction or implication, but it is a process of construction or implication.
Well, my lord, in that case, I would respectfully agree, subject to that particular distinction. I'm seeking to focus at the moment on the process of contractual interpretation, which must, as a matter of logic, arise only after a contract has been made. And the first question that the court must answer in any case is whether that first stage has been achieved. And that, in my submission, is the process which Lord Justice Lewison and Lord Justice McComb found in the Court of Appeal had not been satisfactorily achieved. And the reason they found that was because there was this one term which Lord Justice Lewison described as being of critical importance, paragraph 23 of his judgment, that being the question of the trigger event giving rise to the entitlement to commission, which had not been agreed. Now, in order to determine whether or not, and I should say, in passing, there is no question in terms of the express communications in this case that that trigger event had not been agreed, even on Mr. Devani's evidence. But of course it doesn't stop, and we accept that it doesn't stop with the express words used. The court must look at the conduct of the parties, and it must look at the background against which the communications took place. And the question then arises as to whether the term as to the trigger event is indeed, as Lord Justice Lewison thought it was, so critical that without agreement on that by words or conduct, no contract comes into existence. In my submission, Lord Justice Lewison was plainly right to characterise that in the way he did. And I make good that submission by reference to the three authorities on contractual certainty that are in your Lordship's authorities bundles. The first, if I may, is the Hillas and Arcos case, which is behind tab 10 at page 435. This is a well-known case, and I propose, therefore, to refer to it only briefly. It's a case in which there was a substantial and long course of dealing between a timber merchant and a timber supplier. And in the course of that course of dealing, an offer was made in the form of an option in a letter of the 21st of May 1930. And your Lordships can find the text of that in the left-hand column on page 436 of the authorities bundle. Starting in the middle of the page, your Lordships will see the indented passage. By the document of the 21st of May 1930, the plaintiffs agreed to buy 22,000 standards, softwood goods of fair specification over the season 1930 under the following conditions, and then followed other clauses, and then by clause 9, the option is given. Buyers shall also have the option of entering into a contract with sellers for the purchase of 100,000 standards for delivery during 1931, and so on. And when the buyers sought to exercise that option, the point was taken, somewhat belatedly, and indeed only on the assessment of damages, that it did not give rise to a sufficiently certain agreement. And that was a point that the judge undertaking the assessment of damages rejected, the Court of Appeal upheld, and the matter was then appealed to the House of Lords. Moving into the speeches, your lordships will see the full text of the letter, should they wish to refer to it, on page 443, beginning in the left-hand column and moving into the right-hand column. And then, in the speech of Lord Tomlin, with whom, as we shall see, Lords Warrington and Lord Macmillan both agreed, and indeed Lord Thankerton, although adding some words of his own. First of all, on the left-hand column on page 444, Lord Tomlin said, "The principles are not in dispute. It's in the application of them to the facts of a particular case that the difficulty arises, and the difficulty is of such a kind as often to afford room for much legitimate difference of opinion, to present a problem the solution of which is not as a rule to be found by examining authorities." And I do take that note of caution on board. Indeed, it's repeated in both of the next two authorities that I'm about to refer your lordships to. The ratio of Lord Tomlin's speech can then be found in the right-hand column on page 444 of the bundle pagination, in the paragraph reading the document 21st of May 1930 as a whole. It's about a third of the way down.
Yes, we've got that.
And I'll just ask your lordships to read that and the next paragraph down to capable of being rendered certain.
We will.
Grateful.
Give us 2 minutes. Yes.
Your lordships will see, well, in my submission, the key words are, as Lord Tomlin says, that the term that had not been agreed is something which, if the parties fail to agree, can be ascertained just as much as the fair value of a property. In other words, there's a mechanism that the court could fall back on in order to establish what the agreement was. That contrasts with the present case, where there is no mechanism that the court can fall back on to determine what a reasonable trigger event is, should such a concept even make sense in my submission.
I think Mr. Warnock says that the mechanism here is to say it couldn't matter, because whatever the meaning of the word's introduction, it was satisfied.
But, my lord, that is to fall, in my respectful submission, into another trap, which is to approach the matter with the benefit of hindsight and to say, well, whatever it was done. It's very important to keep in mind that that's not what we're considering. What we're considering is whether there was a contract from the off, from the moment of that telephone conversation, in fact, on the 29th of January 2008. Whatever happened afterwards doesn't matter.
But, I mean, I'm interested you say that, and that may be the conventional view, but is it actually right? I mean, this always arises ex post facto when a disagreement arises, and
well, my lord,
in deciding the significance of the potential difference, whether it mattered is surely quite an important point, because one has to have certainty as to the essential clauses, but actually, if the difference between, say, exchange of contracts and completion doesn't actually make any difference, why should one be fussing about it?
well, my lord, the fact that there is such a significant body of authority, as has already been observed, turning on the fine distinctions between the various forms of estate agency contract is testament to the fact that it matters very much indeed.
Oh, it can matter in some cases, yes, but if it...
But my lord, again, approaching the matter strictly from the standpoint of whether a contract has been made on the 29th of January, which is the basis of His Honour Judge Maloney's decision, it's absolutely paramount, and it goes directly to the point that I've been seeking to make, which is that it is, as Lord Justice Lewison said, a term of critical importance. And without agreement as to that term of critical importance, whether that be by express words or by conduct, there can be no contract.
But there can or not be a contract from the use of very simple words, or the assumption that the parties meant something which can be expressed in very simple words, such as find me a buyer,
Yes.
that leads to a default conclusion as to the trigger point,
Yes.
as Lord Denning explains, because the commission's going to come out of the purchase money,
Yes.
albeit that in the market for these services, when people in fact contract on detailed written terms, they do so on all sorts of different written terms about the trigger point.
Yes. My Lord, I completely accept that, and there are authorities, some indeed arising from oral contracts, where the words are as simple as to find a purchaser.
Yes.
But there is a distinction in my submission between a case where there is some...
Words or conduct, perhaps, you should deal with. Here, and I think you've accepted, it's not just words.
My Lord, yes, I accept that it's not just words, but there is nothing in my submission in Mr. Wells's conduct which would enable the court to form the view that there was any agreement as to what the trigger would be.
No, but there was agreement, wasn't there, from the very fact that the owner was known to be the owner of property which he wanted to sell, and that the other gentleman was known by both parties to be an estate agent whose ordinary business it was to find buyers, that the 2% was going to be for finding a purchaser.
Well, yes, of course, this of course, is on the judge's findings. That
Yes.
is the state of knowledge of the respective parties.
Yes.
But in my submission, there is still a difference between a contract where there is some very rudimentary expression of the trigger event, which is then capable of interpretation, or dare I say possibly even implication, in a set of unexpected facts that then arises. That is the sort of case on one side of the line, and a case on the other side of the line, which in my submission is this case, where there is simply no agreement at all as to the trigger event.
Well, that depends on what the meaning of buyer is. Find me a buyer, and expand on the word finding. But what is a buyer? It's somebody who actually buys the property. That refers to completion. And that's how it's been interpreted in the case law.
My Lord, it's been interpreted against the background of express words used by the parties.
Well, not in both cases, no. The oral exchanges can be skeletal in the extreme,
But there is-
as indeed they were in the House of Lords case on.
It's James, it's perhaps...
Luxor and Cooper.
Yeah.
Well, my lords, they can be skeletal in the extreme, and I accept that. And where there are words skeletal in the extreme, the courts will follow the many exhortations in the authorities to give effect to what the parties meant. But it cannot go so far, in my submission, when there have been no words used.
Well, there is a word. The word is buyer. What is a buyer? Is it somebody who completes the purchase, or is it somebody who simply contracts to complete the purchase but may or may not do so? On the footing that buyer actually means somebody who completes the purchase, one is interpreting the word.
Well, my lord, in this case, I think I'm right in saying that even the word buyer is not used.
But doesn't buyer arise inevitably from the fact that the two persons talking to each other about 2% for something are respectively a seller and an estate agent?
Not inevitably, my lord, no.
Well, what else might the estate agent be getting 2% for doing?
Well, my lord, as the House of Lords said in Luxor, there's a variety of things that an estate agent can contract to do.
Yes, but they all have the common feature that he finds a buyer.
Well, my lords, I accept, as His Honour Judge Maloney said, that ordinarily the most onerous form of trigger event is when a buyer is introduced. But there are infinite variations on that particular theme, and indeed in one of the cases in your Lordship's authorities bundle, the trigger was to find a buyer, not only to find a buyer, but also to do so within a finite period of time.
Well, you can stipulate for that.
Well, of course.
But you wouldn't insert it if it hadn't been agreed.
Well, of course, my lords. And one could also easily envisage circumstances where there's an obligation to find a buyer at a particular price, or the range of possibilities is infinite, and
The range of possibilities is extended by the fact that in addition to the most basic possible deal, the parties are in a position to insert all sorts of bells and whistles on it. But that doesn't help one in a case where nobody suggests they've done so.
well, my lord, that's right, it doesn't, except that it underlines the point I'm endeavouring to make, which is that an agreement as to the trigger is of critical importance. And one can illustrate that by reference to the facts of the present case, where even before the matter had left the court of first instance, there are 4 completely different formulations as to what the trigger event is to be. First of all, if we look at page 121, I'll come back, if I may, to the authorities in due course. If we look at page 121 of the core volume, behind tab 9, we see the learned judge's formulation as it appears in clause 2.2, paragraph 2.2. In the context of a state agent's commission, the term least onerous to the client, and one which no one would dispute if an officious bystander were to suggest it, is that payment is due on the introduction of a buyer who actually completes the purchase. I respectfully suggest that the learned judge perhaps expressed that rather unhappily. What he perhaps meant was the commission is due on the completion of a purchase by a purchaser who is introduced by the agent. So that's one formulation.
Sorry, I can't find your...
4 lines up from
Paragraph, page 121, towards the bottom of the page. C's answer, which I consider well-founded.
Yeah, I see. Due on buyer who completes the purchase, yeah.
Yes, that's number 1.
That's number 1. Number 2 is at paragraph 2.19, 219 on page 126. That's a passage that my learned friend Mr. Warnock alluded to. It follows that I conclude that there was at the material times an oral contract.
Sorry, again, I'm not catching
I'm
up.
so sorry, my lord.
Paragraph 219.
219, page 126.
Yes. Affected, that's where we get the word affected.
Yeah.
Introduction.
Yeah, if C affected
Being
an
the defendant
introduction.
and a prospective...
The prospective purchaser.
As a result of which there was a purchase.
So again,
Yes.
it all turns on what a purchaser is.
Yes.
Well, my lord, on these formulations, yes.
Right. Second one.
Page
Or bought.
134. This is the amended particulars of claim. And you'll see, your lordships will see the pleaded case beginning in the paragraph, it was in the circumstances, towards the top of page 134. Do your lordships have that?
Yes, we do.
It was an express term of the said agreement that the defendant would pay the claimant commission of 2% plus VAT of the eventual sale price of the flats on exchange of contracts with the purchaser first introduced to the defendant by the claimant at any time subsequent to his instruction. So that's yet another formulation.
Well, that accorded with the actual standard terms, isn't it?
Not quite, my lord.
Oh, sorry.
That's the last one that I'm going to go to.
I see. This is the amended particulars.
It is. And then the terms and conditions for selling at page 208. The commission will be due on exchange of contracts with a purchaser, but payable from the proceeds of sale by your conveyance with your written authority. So there are 4 radically different formulations. One can argue as to whether, in effect, they might give the same result in any set of circumstances. But that's
Sorry, what's the difference between the 4th and 3rd?
Well, read literally, my lord, the 4th one doesn't even refer to the need for the purchaser to have been introduced by the agent.
But I mean, that's
That's implicit. Yeah. Whatever else.
Well, it also provides that the commission is due on written exchange of contracts. It then goes on to provide a mechanism for payment payable from the proceeds of sale by your conveyance. But one could imagine an argument if a transaction proceeded to exchange but not completion.
Yeah, I mean, it seems to me, if I may say so, one of your stronger points is that is a distinction between what is said to have been agreed,
Yes.
which was completion, and the contrast with what was apparently in the agent's mind as per his
Yes.
things, which was in fact something different, the
Yes.
exchange of contracts. I mean, that's a sort of sharp distinction.
Yes.
And you're entitled to say, well, if this is all about a meeting of minds, if one mind is thinking one thing, if we know one mind was thinking one thing and the other mind was thinking
Yes,
something else, how do we get a contract?
I can't go quite so far as to say that, because of course one has to accept that it's not about what is in the party's mind subjectively. It's a question of the objective interpretation of the party's communications. It's a highly relevant point in my submission on the cross appeal as to.
But it's clearly something that troubled Lord Justice Lewis, I think.
Indeed.
Much.
Indeed.
That, I mean, in that paragraph I cited, he's obviously troubled about the different formulations.
Yes.
And if
But on
one
the face of
finds certainty, then one doesn't get it.
On the face of it, we're concerned with what the judge concluded about all of this. He didn't accept that the overt conduct or words of the parties led to the conclusion that there was an agreement on everything that was in Mr. Devani's mind. What he concluded was at paragraph 219, which was no more than that the basic minimum, that there must be one, an introduction, and two, to a purchaser. So one simply left with deciding what a purchaser is.
My Lord, yes. The criticism that one makes of the learned judge is the route by which he reached that conclusion, which is clearly set out in paragraph 2.2 and involves the implication of a term. And as I say, that puts the cart before the horse, because it doesn't address the prior question, the logically prior question of whether or not there is a contract at all.
But, I mean, if 219 is really the crucial paragraph, finding, and you're stuck with that, then introduction of a prospective purchaser. We've been looking at all these cases this morning. Lord Justice Denning, Lord Justice Jenkins, construing words like this and suggesting what they would generally mean. And in our case, we've got the Court of Appeal throwing up its hands and saying, can't do it. Don't get to the base.
But, my Lord, the key distinction is that in all the cases that your lordships have been looking at, there are words to construe. Here, there are no words to construe about the trigger event, and that's common ground. Now, the words in the cases that your lordships have been looking at are of varying degrees of sophistication. That's true. But it is a key point of distinction that no words are used by these parties. And the question I'm seeking to focus on in these submissions is whether this is the sort of term that can be incorporated by a process of interpretation or implication, call it what you will. And in my submission, it's not the sort of term that can be. And the reason for that is set out in the three authorities, the first of which I've taken your lordships to, the second of which, if I may, I'll take your lordships to now, which is the Scammell and Alston case, which in my submission is the closest, most analogous case on the facts to the case that's before your lordships. This is at tab 9 of the authorities bundle. The key communication, it's a contract of, well, I was going to say sale of goods. It's, as it turns out, a bit more complicated than that, because on this very simple set of facts, the respondents agreed to purchase from the appellants a new motor van, stipulating that the order is given on the understanding that the balance of the purchase price can be had on hire purchase terms over a period of 2 years. There's then in the head note a slightly more detailed account of the communications, culminating in the words that are quoted in that short summary just over the page, at the top of page 413, using the pagination of the authorities bundle itself. And then your lordships will see just a little bit further down that page in the next paragraph how the dispute arose. Before any hire purchase agreement was entered into, or any agreement reached as to the provisions it should contain, the appellants refused to proceed further, whereupon the respondents brought an action claiming damages for breach of contract to supply the vehicle. And there was then an issue as to whether any contract had come into existence. Now, the judge at first instance and the Court of Appeal unanimously held that there was a contract of sufficient certainty in these circumstances. The House of Lords, equally unanimously, reached the opposite conclusion. There are a number of passages in the speeches that I would just like to refer your lordships to. Viscount Morn, at page 415, agrees with Lord Russell of Killowen. He observes in the next paragraph that it's a regrettable fact that there are few, if any, topics on which there seems to be a greater difference of judicial opinion than those which relate to the question whether, as a result of informal letters or like documents, a binding contract has been arrived at. The ratio of his speech can be found at page 418 of the authorities bundle, halfway down page 257 of the report. He adverts to the fact that there have been a number of different interpretations of this contract, as indeed in the present case, and he concludes on the basis of those interpretations, it seems to me, this is in the middle of page 418, it seems to me that it's impossible to conclude that a binding agreement has been established by the respondents. Moving on then to the speech of Lord Russell, at the bottom of page 418.
Well, that's because, as he saw it, it was conditional on hire purchase terms which were wholly unstated. So you can,
My Lord, yes.
it wasn't a problem that could be resolved by reference to any of the words in the contract or the alleged contract.
Well, I fully accept that.
It might be said, the word purchaser in this case.
But, my Lord, the word, well, again, the word purchaser, its common ground, was never used.
But that is what the judge has found as a fact. Was mutually understood by the parties' overt dealings.
Yes, he's done that by implying a term in order to create a contract.
Well, what do you say the term is that he's implied?
Well, my Lord, it's set out very clearly in his judgment, paragraph 2.2. We've just looked at it.
That it's got to be completion. But that's not what he's found at 219. He simply used the word purchaser without suggesting that there were any express terms about what a purchaser meant. So the question then is, can a court decide what the word purchaser means?
But my Lord, the word purchaser, we must be clear, is never used by the parties. It's said by the judge to be the contract as a result of a process of implication, which I say is illegitimate.
But I don't understand that, because the implication you say that the judge made was that the contract was to be completed, whereas the word purchaser doesn't go into that area at all. It's simply a question of interpretation what it means. And it could be something different to what the parties mentally intended.
Well, it may well have been, my Lord, yes. All that is said, and we must focus on the words that are said by the parties, rather than, with respect, the interpretation placed on those words by the judge. All that is said by Mr. Devani in the course of this telephone call are that my fees are 2% plus VAT.
Yes, my fees for doing what?
Well,
finding a purchaser. That was obvious.
Yeah.
Well, my Lord, in my submission, it's not obvious.
Well, what else was he doing?
Well,
never mind about the
exchange of
point. What was
contracts. This is the
job?
distinction, the exchange of contracts. I mean, the fundamental difference is between a contract which goes to exchange of contracts and one which goes to completion. And there were two parties who we know apparently had different, well, we know one of them had a clear view on what it meant, which was not what was ultimately agreed. So it would be quite different if we didn't have any view about what was said, but we here know that the agent normally contracted on terms that the relevant date was the exchange of contract. And yet here we have it being found that he agreed something different.
Well, my Lord, yes. I mean, the agent may well have known the terms on which he normally contracted on his version of events, but Mr. Wells...
what would have happened if Mr. Devani had actually sent his terms, but Mr. Wells didn't notice that point, and the evidence was he assumed it would be on completion. And so we actually have evidence that they both, on the facts known to them both, their minds weren't at idem on that particular point. You would have said there wasn't a contract.
Well, the court would have to do what it would always do and construe the communications objectively. I mean, one might get into difficulties of the postal rule or goodness knows what, which would take us down a completely different avenue. But in deciding whether or not there's a contract, the court simply has to look at the
But would that situation, the answer be, well, there isn't a contract at all, or actually it doesn't matter in the way things have turned out?
Well, my lord, in my submission, the answer would be, if you cannot, on an objective interpretation of the communications and conduct, identify sufficient consensus between the parties, there is no contract. And it doesn't matter.
Even if it's on a point which no one cares a jot about in practice.
But I'm troubled by your lordship's reference to as things turned out. It doesn't matter. We're not concerned with how things turned out. We're concerned with the question of whether the communication...
Yeah, but in practice, it wouldn't have mattered at all, except in the event. I mean, they would proceed on the assumption that actually completing exchange of contracts was likely to lead to completion. And so in the ordinary course of events, it wouldn't matter the difference. It's only if that doesn't happen that there's a problem.
Well,
so can't we assume that they were contracting on a basis which the likely result?
Well, my lord, no. That assumption simply can't be made. Why should it be made? I mean, there's a variety of possible estate agency schemes, just as in the Scammell case, there's a variety of possible hire purchase agreements. The only difference conceptually between the Scammell case and the case we're concerned with now is that in the Scammell case, the range of possible hire purchase agreements undoubtedly is genuinely infinite. One can never say, well, this is the most onerous form of hire purchase there can be. In the present case, I accept one can say, well, ordinarily the most onerous form of estate agency contract there can be is that the trigger is only, or the commission is only paid on completion. But that is the only difference between these cases in my submission. And given that your lordships are concerned to answer the question, do these communications between Mr. Wells and Mr. Devani give rise to a contract on the 29th of January 2008, the cases are indistinguishable.
The minimum that they must have been meant by my terms are 2%. My terms are 2% for finding you a buyer, whatever buyer may mean. I don't see how it can mean less than that. So what they've left uncertain is what buyer means. Now, you say that prevents a contract coming into being, but if the court is in a position to say what buyer means, that submission fails.
But, my lord, there are more onerous forms of estate agency contracts still. For example, the one that stipulates that the buyer must be found within a certain period of time.
Well, if they'd said that, then that would be an additional condition.
But the point is, my lord, that you're selecting, if I may say so, you're selecting an arbitrary trigger event from a theoretically infinite scale of possible trigger events, some of which are more onerous than the one that's been settled on, and some of which are less onerous than the one that's been settled on.
Is your point that if they had had a more detailed negotiation, they might have insisted on additional terms, e.g. as to the time within a buyer, which the buyer must be found, the price at which it must be found? Is that the point?
Well, they clearly might have done, my lord.
But is that the point that you're making?
But, well, I can't speculate as to what would have happened, my lord. All I can say, all I can argue, is that the communications that did in fact take place were not sufficient to give rise to a contract.
But are you submitting that the fact that they might have agreed something along those lines, time limits, price bound, and so on, means that the words, that the deal, find me a buyer, whatever buyer may means, are not enough? Is your case that the possibility of further terms is enough to make that not a contract?
Yes, my lord, that would have to be the effect of my submission, that the possible spectrum of trigger events goes beyond what has been treated as the ultimate trigger event, namely to find a buyer. But I fear I'm in danger of repeating myself, indeed I probably have done several times, but the words to find a buyer, your lordships must be clear, were never used. 2% plus VAT, that's all that's said. And as Lord Justice Lewison says in his judgment, there are a number of things that are missing from that communication. It doesn't even say whether there's what the 2% is to be calculated on, and certainly doesn't say what the trigger event is. It doesn't even say that Mr. Wells agreed to it.
But again, it's obvious that the 2% is going to be calculated on a sale price.
Well,
obvious from the relationship between the parties of a seller and an estate agent. If it's going to be paid on a sale price, it's going to be paid by a buyer.
Yes.
So why doesn't it follow inevitably that the job for which he's getting his 2% is finding a buyer?
Yeah. Well, my lord, I can see the force of that, and indeed the the mere fact that there was a deficiency in the question of 2% of what is not what troubled the Court of Appeal. The problem that troubled the Court of Appeal, or the majority of the Court of Appeal, was that it was the trigger event itself that wasn't expressed. But if I can just finish this very short...
Certainly, I mean, you said, and we've noted it, that you think you submit Scammell is very close to the present case, Mr.
My Lord,
Arthur.
yes.
Well,
Yes, indeed.
So be it. Where do we go from Lord Moore?
Well, my Lord, if we could go into the speech of Lord Russell.
Yes, very well.
He identifies the question at the bottom of page 418. The point of which ultimately emerges is short, depends on the question of whether any and what certain meaning can be attributed to one sentence in a letter from the respondents to the appellants. He then goes on to say over the page, I get no help from any of the authorities that were cited in the debate. Again, one takes that on board. The 5 different interpretations that had been put on this letter by the time the matter reached the House of Lords are then set out at page 259, page 420 of the authorities bundle pagination. The first is in the paragraph beginning, the trial judge was of opinion. The second is in Lord Justice Slessor's interpretation as recorded at the bottom of page 420. The third in the interpretation of Lord Justice McKinnon over the page on page 421 of the report. The fourth is the interpretation of Lord Justice Goddard, just in the paragraph below that. Leading counsel supported the analysis of the trial judge. I'm now just below the halfway point on page 421. And junior counsel came up with another interpretation of the possible contract. And as Lord Russell
there was such a
says,
vast gap, wasn't there, in what the arrangements were going to be, that fertile minds could have different suggestions.
Indeed, my Lord.
We've got to decide whether this case actually is of any assistance to us. You submit that it is.
My Lord,
now,
yes.
where do we go next?
Let me take you, my Lord, to the 2018 decision of the Court of Appeal in the case of open work, behind tab 18 at page 590.
Thank you.
This draws together the threads of the 2 cases that we've just looked at in my submission, in obviously a very modern context. And the context is a franchise in which the franchisee sells investments to clients. And on the sale of an investment, both the franchisor and the franchisee receive a commission. Paragraph 9 in the judgment of Lord Justice Simon refers to the fact that one of the terms of the contract between Open Work and Mr. Forte, that's the franchisor and franchisee, provided that if the investor withdrew the funds within 3 years, there was an obligation on Mr. Forte to repay a proportion of his commission to Open Work. And that's referred to as the clawback provision. And we then see the clawback provision set out in terms at the bottom of page 592. No exit penalty bond. Where funds are withdrawn within 3 years of the most recent investment, a percentage of the initial commission will be debited to your commission account. The amount of initial commission clawed back relates to the amount invested, length of time invested, and amount withdrawn. Your Lordships will be able to see why this clause gave rise to difficulty, because nothing more was said about the mechanics. Over the page, on page 593, the dispute is articulated in paragraph 16. The dispute is whether the clawback provision was sufficiently clear in specifying how it was to operate. And then paragraph 24, it's now on page 594, yet a further warning that although the authorities indicate that cases in which contractual provisions are challenged as being void for uncertainty are decided on their own facts, and the court should not transpose a decision on a term in one case to a contractual provision in another, there is clear guidance as to how courts should approach an argument that a contractual provision is too uncertain to be enforced. The court then considered the cases of Hillas and Scammell, to which I've just referred, Your Lordships. And if we move ahead to paragraph 29 on page 597, Your Lordships will see that there are a further number of cases referred to, which Lord Justice Simon says do not assist on the facts of the present case. He says, if one were to look for a short synthesis of the court's approach to the issue, one cannot do better than the summary set out in Sir Kim Lewison's interpretation of contracts under the heading, The Test of Uncertainty, in which he says a provision in a contract will only be void for uncertainty if the court cannot reach a conclusion as to what was in the parties' minds, or where it is not safe for the court to prefer one possible meaning to other equally possible meanings. And I submit that that encapsulates very concisely the difficulty with the appellant's case. Because neither this court... Yes, my learned friend is asking me to read on, and I'm perfectly happy to do so, while bearing in mind that what is in the party's mind is a legal construct and not an inquiry into subjective intent. Now, I fully accept that and have accepted that many times in the course of this submission. But it makes no difference to the key point. The question is, can the court safely conclude what, objectively speaking, is in the party's minds, or is it not safe for the court to prefer one possible meaning to other equally possible meanings? And I submit...
Mr. Butler, it is of interest that Sir Kim there refers to whether it's not safe for the court to prefer one possible meaning, because the discussion in this court today has been very much that it is entirely safe to prefer one trigger event to another, because all possible events have been satisfied.
But, my lord, again, with respect, that is to focus on what happened afterwards, what happened after the event, and not on the question of whether the communications of the 29th of January, if we take a snapshot there, gave rise to a contract. That's the point. And the court cannot safely say, as a result of that discussion on the 29th of January, what the trigger event was. There are any number of possibilities that could have been in the parties' minds, even on an objective analysis of their communications. And the ultimate application of this in the present case, and we see that in paragraph 31, was that the Court of Appeal find that the judge was correct to find that the party's intention was reflected in a straight-line calculation of entitlement to clawback. Such a basis for clawback, although not expressed, gives effect to the identified criteria, effectively a sort of mathematical approach. And clearly the court did not want to be left in a position where no effect could be given to that particular provision. Now, you can't take any mathematical or quasi-mathematical approach with the situation before your lordships at the moment. There is simply no reason to prefer one trigger event over another. There is, as a result of that, in my submission, no contract.
Well, we have that point.
Grateful. My lords, that, I think, is all I want to say on the appeal. May I move on to the cross-appeal?
Please.
The starting point here are the words of the Estate Agents Act and the regulations. May I just quickly draw your lordship's attention to those? They can be found at page 267 of the authorities bundle. Section 18 of the Estate Agents Act 1979. If your lordships have had an opportunity to look through these, then I'll take it very quickly, but I'll be guided by your lordships.
Be guided by me. We have looked at Section 18.
I'm very grateful.
And, of course, at the regulations.
I'm very grateful. Well,
at some stage, perhaps earlier rather than later, you might tell us what our approach should be to an evaluation and an exercise of discretion, respectively, under Section 18(6).
My lord, yes. If I may, just before leaving the text, I'm sure your lordships have picked up on the fact that 18(6)A requires the court to dismiss an application to enforce, if but only if it considers it just to do so. So that's the first, if I may use the phrase, trigger or criterion. To do so, having regard to, then one might interpolate a small a, prejudice caused to the client by the agent's failure to comply, and b, the degree of culpability for the failure. So those two criteria. And then when we move on to b, the consideration of culpability drops out of the picture. In determining whether or not there should be a reduction, the court is only concerned with prejudice. So if, as was the case in the present case, the judge considered that the agent's conduct was culpable, the only way to reflect that was by not permitting the contract to be enforced. Now, I don't go so far as to say that at any time the court considers there's culpability, it should not enforce the contract, that would clearly be to write words into the section which aren't there.
It would be to write words out of the section which are there.
Well,
have a degree of culpability.
Indeed. But in my submission, it is a clue that if there is, as I submit there was here, a very high degree of culpability, then the only place, the only stage of the process at which that can be reflected is in the question of enforcement under 18.6.
Do you accept that when you've got questions of degree in the course of an evaluative process, that an appellate court will only interfere if the judge has either made some error of principle or attached a degree of weight or lack of weight to
Yes.
particular factors
Yes.
that is simply, well, plainly wrong is the view.
Yes,
It's wrong beyond real argument.
Yes, I think the words plainly wrong caused some difficulty in the authority of INRI B.
Yes.
But I do, of course, entirely accept those well-known principles. What I am going to submit in due course to your lordships is that in this case, it wasn't simply a question of the weight that the judge attached to various factors, but he actually completely mischaracterized both the culpability and the prejudice. And so his discretion was exercised on an erroneous view of the factual matrix, primarily, but also on erroneous legal principles. And the Court of Appeal, although they identified this and made a number of criticisms of the way that the judge exercised his discretion, and again, one should be careful about one's words. I use the word discretion. I think we probably agree, as Lord Justice Lewison said, it's really a question of value judgment.
I thought he said A was evaluative and B was discretionary, but perhaps it doesn't matter.
My Lord, perhaps it doesn't matter. I think the question is, from the point of view of 18.6a, it either is just or it isn't. One can't have a discretion as to whether it's just or not.
Well,
so it's a value judgment. But the point is that it was not simply a question, in the judgment of Judge Maloney, of attaching a degree of weight to one aspect that the Court of Appeal perhaps felt was unjustified. Of course, in those circumstances, we would be in the territory of giving the judge a fair degree of leeway. It goes beyond that, because as we'll see, the Court of Appeal said that the learned judge basically mischaracterized certain aspects of the factual matrix completely. But if I may just move on to the question of the approach that your lordships should take to the construction of this provision. My task is somewhat hampered by the fact that there's very little judicial guidance to be found in the authorities. There are perhaps three cases to draw your lordship's attention to, two in the authorities bundle and then the decision of the Court of Appeal itself. And I don't really argue with what Lord Justice Lewison said and his colleagues agreed with about how the discretion should be exercised. So the first case is behind tab 23. It's Solicitor, Estate Agency and Mackayber, beginning at page 712. Now, I'll just tell your lordships briefly what the facts of this were. There was a failure by the agent to comply with Section 18 in that the agent did not tell the client about certain discounts it received on block advertising. It's a Scottish case, as your lordships can see. And block advertising in the Glasgow Herald entitled the agent to a discount which it did not tell the client about and did not pass on to the client. That was the extent of the failure.
There was an indemnity against that kind of marketing expense, was there?
Well, my lord, in the outcome, yes, that's right, I'm sorry, yes, in the contract there was, yes. And we'll see that in the outcome of this case, the client was allowed a reduction so that the discount should be passed on to him. But just in terms of guidance as to how the approach should be exercised, can I draw your lordship's attention to page 327? I'm afraid that this, and this I should say is the sheriff's judgment, the first instance judgment. The reporter doesn't seem to have bothered with paragraphs, so it's rather difficult to give much guidance as to where we are. But do your lordship see...
Electronic 724.
724, my
Yeah.
lord, yes.
Yeah.
About halfway down the page, on page 724, there's a sentence beginning, having regard to these elements of prejudice and culpability. Do your lordship see that?
How far
I
down?
found it.
Just above halfway.
Oh, yes,
Yeah.
all right.
The learned sheriff says, I'm bound to dismiss the application if, but only if it's just to do so. The use of the word just appears to me to import equitable considerations, which require me to attempt to strike an equitable balance, having taken the required factors into account. Section 18.6a, as the defendant's agent pointed out, is to an extent penal in nature and rather draconian in effect, since it does not allow the court to pick and choose which parts, if any, of the contract should be enforced. If it's just to do so, the court must dismiss the application and thereby deprive the pursuers of any payment under the contract. There's a little bit of guidance there. The sheriff goes on to say, in that context, it's an important feature of the present case that there's been a failure to comply with only one part of the obligation under Section 18. He characterises the pursuers as significantly culpable, but he says it would not be just, in my view, to dismiss the application and thereby deprive the pursuers of any payment. He goes on to say at the bottom of, or towards the bottom of page 724, I'm moving on a few sentences, do your lordship see a sentence beginning, however, as was accepted by both agents? About 12 or so lines up from the bottom.
Yeah.
Yes.
Grateful. The number of breaches and the nature and significance thereof may be of importance in the final analysis when the court is considering the question of dismissal. And the culpability of the pursuers in the present case with regard to the breach of that part of their obligation contained in section 18.2d is of a significant degree, but taken in the context of the obligation as a whole, it is not of such significance, either taken in isolation or in combination with the prejudice, as to lead me to hold that it would be just to take the draconian step of dismissing the application. Now, there's some discussion in the later authorities that we'll look at about whether one looks at prejudice and then moves on to culpability and then mirrors that up to justice, or as Lord Justice Lewison preferred, to do it in the round. I don't take any particular issue with Lord Justice Lewison's approach, which in respect seems to me to be plainly sensible. Now, just looking over the page in the sheriff's judgment still, he then turns...
This is a judgment that was later set aside, is that...
Yes, let me explain why, and perhaps I can move more quickly through it. The sheriff perceived that there was only one failure under section 18.2d, and that was to, I think, highlight other terms which give rise to a right to remuneration. The sheriff principal said, well, that's not quite right, because actually this comes within the definition of remuneration in 18.2a, so there is a dual breach, if you like, albeit arising out of the same facts. And the sheriff principal took the view that that was enough to entitle him to exercise the discretion again, and he declined to enforce the contract. The Inner Court of Session then allowed the appeal, saying, well, yes, although the sheriff mischaracterised the number of the breaches, he basically exercised his discretion on the correct factual matrix, and therefore there was no room for the sheriff principal to interfere. That, in very short summary, is the case. But so far as principal is concerned, the sheriff principal, we will see at page 330, quotes the passage that I've just read from the judgment of the sheriff and says, and I'm now midway down the second paragraph on the page, on page 727 of the authorities bundle, your lordships will see the paragraph beginning, he then goes on to consider the question of prejudice. And he then cites the passage I've just referred to, and he says below that, and please stop me if I'm taking this too quickly, I respectfully agree with the sheriff's interpretation of the provision. Do your lordship see that?
Yeah.
Arguably, you're taking it not quickly enough.
Well,
because this is a judgment that you say was reversed. In the
well, my lord, it was reversed, but only because, as I say, the view was taken that it wasn't a legitimate...
well, if there's a nugget here, let's burnish it.
Well, my lord, I'll try to...
Otherwise, let's proceed.
Indeed, indeed. My lord, I'm not sure that there's anything I can draw your lordship's attention to beyond what I've already drawn your lordship's attention to, which qualifies as a
But I
statement.
mean, we've got, you accept the way Lord Justice Lewison put it, so...
I'm sorry, my lord.
You agree with the way it was put by the Court of Appeal in our case,
My
so...
lord, yes, I
we
do.
need
Let me move on.
great
It may
respect to the
be that I'm taking up time unnecessarily referring to these authorities. To the extent that they're relevant, they're properly referred to by the Court of Appeal, and therefore there's perhaps no need to dig any deeper into what they say. Let me move straight to the facts of the present case. Again, I can take these fairly quickly. We know that there is no attempt at compliance with Section 18 by Mr. Devani until the 5th of February 2008, by which time the property hasn't been sold, but the introducer has been, that the purchaser has been introduced and has agreed to buy. At that point, Mr. Devani emails to Mr. Wells the terms and conditions, which we've looked at already at page 208. I don't need to take your lordships back to it, but it's worthy of note that they begin with the words, "I am required by Section 18 of the Estate Agents Act 1979 to set out our terms of business prior to you formally instructing our company." So Mr. Devani clearly knew what the requirement was, and that, in my submission, goes to culpability. The terms and conditions, as we've seen, misquoted what has now been held to be the trigger event, and it therefore follows that there was no compliance at the time, and there is still no compliance to this day with the requirements of Section 18. Not only that, but the position is worse than if Mr. Devani had said nothing at all, because, of course, what he's done is to put into circulation an erroneous statement of the true terms of this contract. He doesn't give any explanation.
Well, what he was effectively trying to do was not to put forward a statement of what had already been agreed, but to add further and more detailed terms, which does sometimes happen.
Well, my lord, the point I've just made, I hope, is an accurate point. There may be mitigating circumstances, as your lordship observes, but it is true, incontrovertible, I would say, that there has been no compliance with Section 18, even now.
Yes. No, there's not been any writing.
My lord, no. There is no explanation. Lord Justice Lloyd, in the Great Estates case, said, and Lord Justice Lewison agreed, that it's incumbent on the agent to provide an explanation. There is no explanation, and your lordships have Mr. Devani's witness statement in the bundle at page 153, and they will look in vain, I think, for any explanation of why Section 18 wasn't complied with. Let's just look at the judge's judgment of first instance. The pertinent paragraphs here are paragraphs 4.6 and 4.7. They're on page 128 of the core volume. Perhaps I could just ask your lordships to remind themselves of the terms of paragraph 4.6 and 4.7 of the judgment.
Of course. We'll read them again.
Grateful.
Yes.
I'm grateful. And then we can move on to the Court of Appeal's judgment. The relevant passage begins on, or the treatment of the issue as a whole begins on page 99, paragraph 42 onwards. There is then a detailed consideration of prejudice and culpability beginning at paragraph 56 on page 103. There is a very slight potential difference in interpretation between Lord Justice Lewison and Lord Justice Lloyd at paragraph 64 on page 105, where Lord Justice Lewison says in the middle of paragraph 64, if Lord Justice Lloyd meant to say that culpability and prejudice had to be considered sequentially and separately in answering the question posed by section 1868, then I would respectfully disagree. Whether or not that is what Lord Justice Lloyd meant to say is perhaps moot. I respectfully adopt Lord Justice Lewison's approach to the interpretation of the section. But then from paragraph 68 onwards, we move into a series of criticisms of the judge's judgment. And the first one at paragraph 68 is that Mr. Devani mischaracterised, the judge's treatment of culpability mischaracterised the effect of speed. Lord Justice Lewison says, far from being a mitigating factor, it was, in my judgment, an aggravating factor. And I might just ask your lordships to cast their eyes over the rest of paragraphs 68 and 69. Paragraph 69 records the judge's finding that the main prejudice caused to Mr. Wells was that of uncertainty. He there refers to the fact that the written conditions provided don't accord with what the judgment said about the terms of the contract. And then in paragraph 70, he moves on to further prejudice, being the exposure of Mr. Wells to a potential second claim from another agent.
How could that have arisen? The other agent wouldn't have introduced the same purchaser?
Because the other agent was operating under a sole agency, my lord, and there was a penal provision in the event that sale was eventually effected through a different channel.
I see.
But I mean, I don't know quite what happened to that. The judge seems to have taken the view that by the time it got to him, that had dropped out of the picture as a practical concern.
Yes. Yes, that's right.
I would take that view.
Yes, that's right. And in fact, the Court of Appeal largely agreed with that, and we'll see that in paragraph 72. Lord Justice Lewison says, that said, I consider the judge was entitled to take into account the fact that Shaw had in fact made no claim. And it must not be overlooked that the judge was dealing with the case after the expiry of the limitation period. Whether it's just to enforce the contract is not, in my judgment, to be decided by reference only to considerations frozen in time at the date when the contract was made or performed. Now, I submit that's slightly problematic, in fact, because, of course, limitation periods don't simply come to an end 6 years after the event. It's perfectly possible to conceive, even now, that Mr. Wells might be exposed to a claim if this is to be...
But surely that was a matter for the judge to form a view on the practicalities of that. I mean, we can't interfere with that.
My lord, yes, I would respectfully...
Funnily enough, Lord Justice Lewison puts this down as secondary prejudice, not the main prejudice. And we thank you for drawing our attention again to 69, uncertainty. Poor Mr. Wells, he simply didn't know what the trigger event was. Well, we'll have to form a view about how concerned he was not to know what the trigger event was. Well, is there any evidence that he asked, well, what's the trigger event going to be? I'm very uncertain about this. So it may be that the new point that is there insinuated by Lord Justice Lewison isn't much of a point.
Well, what your lordship must keep in mind in terms of the evidence is that none of what we're talking about at all accords with Mr. Wells' account of what happened. Of course, he's bound by the findings of fact of the judge in the first instance.
Yes.
But the answer to your question is there's no evidence he ever questioned the trigger event because he says he didn't think Mr. Devani was an estate agent at all. Yeah. He thought he was an investor, an interested buyer.
But the trouble, as you say, I mean, we know that he gets Mr. Devani's terms, which are actually more rigorous than the ones I mentioned you found, very shortly afterward, on the 5th of February, and he doesn't immediately say, gosh, that's terrible, I can't.
Well, there's some...
And there's no evidence that he caused him any prejudice at all, is there?
Well, in my respectful submission, there is evidence that he was caused prejudice, and both the trial judge and the court...
no evidence that he thought he was caused any prejudice.
Well, I mean, if we want to go into the evidence of what Mr. Wells thought on his version of events, he just thought it was a big trial. He thought Mr. Devani was now presenting himself as an estate agent on 2% commission, and he just didn't want to deal with it.
There's the judge found against him, and
exactly, and here we are.
he was trying to get out of the...
Yeah.
But all of the criticisms that the Court of Appeal makes of the judge are essentially criticisms to the effect that he attached too much weight or thought too much of particular points. Or in some cases, not enough. They are all weight points, aren't they?
I would respectfully disagree with that.
I see.
I think that is that's a fair characterisation of the point of paragraph 73. If I can just list what the criticisms are. We've looked at the one in paragraph 60.
They're in your printed case, aren't they?
My lord, I think they are.
Yes, there are three of them that you summarise at page 78 in paragraph
Lord, yes.
45.
Yes, 68, 71 and 73. It might also be said that I've omitted from that list a criticism in paragraph 70, that the judge brushed aside the possibility of the rival claim on the ground that it was speculative. This was despite his finding that if Mr. Wells had the terms before being contractually bound, it was likely that he would have consulted his solicitor and they would have discussed the implications of the clause. Although the judge said that Mr. Wells might have gone ahead anyway, might is a slender foundation upon which to downplay the prejudice. Again, it was found in the Great Estates case that the possibility that a client might have acted differently is enough to give rise to prejudice, and Lord Justice Lewison agreed with that. So there are really, I would submit, three criticisms of the judge in paragraphs 68, 70 and 71, and then half a criticism perhaps in paragraph 73, where in answer to my submission that the quality of the job done by the estate agent is an irrelevant factor, is described by Lord Justice Lewison as having some force, but he says it does not follow that if the estate agent has done a particularly good job, that is irrelevant, at least to the question whether it is just to dismiss the claim. Lord Justice Lewison says, I do not consider that fact was irrelevant. Now, that is a classic example of a point where perhaps the appeal court disagree with the weight that a judge has attached to a particular point, but not going into the realms of interfering with the exercise of the judge's value judgment. But the first three criticisms in paragraph 68, 70 and 71, in my submission, are more fundamental than that, because what they mean is that the judge was simply looking at the factual scenario before him with erroneous eyes. He, in particular, did not properly evaluate the prejudice to Mr. Wells. He treated speed as being a mitigating factor rather than an aggravating factor. That's a very serious error in my submission. Not only is it a question of saying, well, he gave it a bit more weight than we think he should have done. What's being said is he should have put that on the other side of the account. It should have been a debit rather than a credit. And so in that respect, and in these other two respects in paragraph 70 and 71, the judge has simply fundamentally misevaluated both the culpability and the prejudice, which are the cornerstones of the exercise of the value judgment.
Why was it an aggravating factor? I mean, you know, speed obviously comes into it. It needed to be done quickly, and it may have been thought that wrongly that getting the crucial thing was to get the job done, not necessarily to worry about the details too much. Now, that's culpable, but it's not. Well, it's a factor, isn't it, which you can take into account.
Well, my lord, on Mr. Devani's version of events, there is what is on any view, and I'm not saying anything controversial here, a very vague telephone call which doesn't deal with all the terms that ought to be dealt with. There's then an almost immediate introduction to a purchaser who agrees to buy, and then only after that are these more detailed, albeit still erroneous, terms and conditions sent. Now,
the die was cast, wasn't it, when the introduction was made, provided that the person introduced subsequently entered into a contract. Either thereafter, if there was a contract, Mr. Wells was on the hook for the 2%, and if there wasn't a contract, Mr. Devani was at his mercy because he got the information he needed. So I'm inclined to think that speed actually does cut both ways.
well, but my lords, the question is whether what the Court of Appeal did, the exercise they adopted, was appropriate here. Because, and even if it's the case that it cuts both ways, as your lordship characterises it, that still differs from the approach adopted by the judge, which is to put it very much in the credit column, as far as Mr. Devani is concerned. The Court of Appeal would have put it in the debit column. Your lordship would probably put it somewhere in between. But
the judge didn't really put any real weight on the submission about speed. I mean, he recites it as a submission being made by the claimant, and he says, well, it's true as a matter of fact, but it's only very partial mitigation. He could just as well have sent the terms by email on the 29th and could have waited until they were accepted before proceeding. I mean, the overall impression you get from paragraph 4.6 actually is that the judge is recording a submission and not really giving it much credence, other than it being factually correct.
well, paragraph 4.6 goes a little bit beyond that in my submission. His Honour judgment only says, while this is true, it is only very partial mitigation. So it's clear just from those words that he is putting it in the credit column, if I may continue that
But to a very minor
analogy. Possibly yes, but if the Court of Appeal characterise it differently in my submission, it's not good enough for them to say, as they go on to say, we're just not going to interfere with the judge's value judgment. Because particularly in a situation where you have just two elements going into the melting pot, really, which are prejudice and culpability, measured against the overall criterion of justice. If you mischaracterise them both, it's very difficult in my submission to say that that is a valid exercise of a value judgment.
Well, what the Court of Appeal is essentially saying is we wouldn't necessarily ourselves have reached the same conclusion as the judge, but we think that the judge's view is within the permissible limits which the material made possible.
Well, the answer to that, my lord, is that having said what they said and made the criticisms that they unanimously made about the judge's behaviour, it was incumbent on the Court of Appeal to exercise the discretion afresh. If I may put it in this way, looked at from my client's perspective, to ask the rhetorical question, has he ever had a proper evaluation of the value judgment required under section 18.6a? The answer is no, he hasn't. Because the first instance judge simply approached it through a factual prism that the Court of Appeal held to be erroneous in both the respects of prejudice and culpability, but then went on to say, we're not going to interfere with his value judgment. The fact that this is not just an academic point is demonstrated by Lord Justice Lewison's observation that although he was far from sure that he would have reached the same conclusion as the judge, well, Mr. Wells was just entitled to know what the conclusion should have been on the proper exercise of that value judgment on the basis of a proper analysis of the facts. And he's never had that to this day. So that's why what the Court of Appeal did was ultimately unsatisfactory. Their criticisms, I respectfully agree with. I would submit that perhaps in certain respects they didn't go far enough, and the reasons for that are detailed in my written case. But even given the extent to which they did go, their findings must surely call for the fresh exercise of the value judgment on the basis of the correct analysis of the facts and of the twin factors of prejudice and culpability, which are the only two ingredients that go into it. So that's why, in that respect, the Court of Appeal fell into error. It wasn't simply...
You're hitting your head here against the agreed test for appellate interference with a decision such as this. The agreed test is whether it was wrong, and the Court of Appeal couldn't bring themselves to say that it was wrong. So you didn't get through that hurdle. So you're not entitled to say, we were entitled to a fresh examination of this by the Court of Appeal.
Well, I'm entitled to say to this court, and I do say to this court, that the Court of Appeal was itself wrong in the way that it approached this. And indeed, had the Court of Appeal adopted a different approach and said, we put all the factors into the equation as they properly were, and exercising our discretion or the value judgment afresh, we come to the same decision, this is Honour Judge Maloney, that would have been one thing. I could see that I would be in difficulties because my client would then have had a fair judicial evaluation or exercise of the value judgment.
They don't have to come to the same conclusion as Judge Maloney. What you've got here is a double evaluation. You've got an evaluation by Judge Maloney, and then you've got a further evaluation by the Court of Appeal, which says, well, there are things that we wouldn't have decided about this exercise, but our evaluation is that they are not of sufficient significance to take it outside the range of possibilities properly open to the judge.
Well, it may be a question of the correct reading of Lord Justice Lewison's judgment, but I read him as saying that he, and therefore by extension the rest of the Court of Appeal who agreed with him, are simply not going to conduct the evaluation again. And in my submission, they should have done, given that as I say, the only two factors that go into it, they found that the judge had mischaracterised, and mischaracterised not only in terms of the weight he attached, but in one case by regarding what was in fact an aggravating feature as a mitigating feature. My Lords,
is there much more to be said, Mr. Barker?
I've made all the points I can make.
I think you probably have.
And unless there's anything else I can assist your Lordships with.
Well, thank you very much indeed. I don't think that there is. But now, look, Mr. Blakeney, are you going to follow? Very well. We'll rise for a very, very short time. Mr. Warnock, we don't need to hear your submissions on the cross appeal. We'd like brief headline submissions on any aspects about your appeal touched upon by Mr. Butler, which you want to deal with.
Well, there's just
he did make a point about the mismatch between the judge's finding as to what the trigger event was,
yes,
and the terms. And you might like, among other things, to address us briefly on whether we should be concerned about that.
Well, that's the point I was planning to take my Lords to, and I was going to take my Lords back to the Marks and Spencer's case and the judgment of Lord Newburger. And it is at, sorry, I've just lost it, tab 16. Yes, Marks and Spencer and BNP Paribas Securities.
Yes?
And at paragraph 18, now this is in the context of implying terms, but nonetheless it refers to a more stringent test. But at paragraph 18, his lordship had referred to the well-known BP refinery in Westernport and Shire test. quoting from Lord Keith for the implication of a term.
Yes.
Paragraph 21, having along the way considered the, Lord Bingham's consideration of a case involving written contract terms, but at paragraph 21 he set out some commentary on this, and he made a few points. And the first of those is I draw attention to in relation to this is letter G. Lord Steyne rightly observed that the implication of a term was not critically dependent on proof of an actual intention of the parties when negotiating the contract. If one approaches the question by reference to what the parties would have agreed, one is not strictly concerned with the hypothetical answer of the actual parties, but with that of notional reasonable people in the position of the parties at the time they were contracting. So the fact that Mr. Devani might have preferred or had in his head the idea that the trigger event would take place at the time of exchange matters not, because he introduced that term later, but what one's looking at is what the parties, objectively speaking, must have had in mind, not these actual parties, but hypothetical parties in their position. I submit that is the answer to that.
Thank you. Yes?
A point was made that terms more onerous could be implied, such as, for instance, relating to the timing of the event. But of course, that's a term as to timing. I think that a term as to timing is different from a term as to what the event is. And here, if parties want to agree additional terms, well, then they can do that. But here the question is what the trigger event is, and the judge and Lady Justice Arden, we say, properly construed that. Whether one approaches it as a question of interpretation, which we say is probably the right analysis, or implication.
Yes, I think Mr. Butler had in mind probably, was it the Midgley case?
Yes.
You find a purchaser within 3 months. He was simply saying there's this enormous array of trigger events.
Yes. And of course, one could negotiate and specify any number of terms, but the question is what that additional term related to the timing of the trigger event in this case. But here we're concerned with what the trigger event is.
Yes?
My Lord, unless my Lordships had any further points they wanted to raise with me, I didn't propose.
I think not. Well then, thank you very much indeed, Mr. Warnock, Mr. Butler, and the juniors. Good written cases, economical submissions covering all the points, just what we want. We'll reserve judgment.